Hi everyone, I'm Danae Oosthuizen. It's just 12 and today we will be looking at learner disciplinary hearings in public schools. I hope that you guys have a wonderful week. Last week before the learners return back to school. This week we're going to focus a little bit on learner disciplinary hearings. So today I will be discussing the disciplinary hearing procedure in total, and on Thursday we have a session where we will specifically focus on the role of the evidence leader, because the evidence leader plays such a really important role in disciplinary hearings. So today I'm not going to address the role of the evidence leader, and we will be doing that on Thursday. So again, PowerPoints will be sent to all member schools in English and in Afrikaans. And today we will be dealing with questions in the following manner. Please use the chat function where you can just type out your question. We will answer the question at the end of the session, alternatively via email. It's just if we run a little bit out of time today, we will then be able to just answer your questions via email. So also just include your email address there, but I really hope that we'll have enough time to also address some of your questions. Then please follow us on Facebook. And lastly, we had a few requests from our schools and from people that we make this presentations available to you. So what we will do is we're starting a YouTube channel where we will upload all of the training sessions after the series has been completed. So you can then go and look at everything that we had to offer during this free training series. So let's jump right into it. I can probably speak to you for days on end regarding learner disciplinary hearings. And so I'm going to jump straight into it. And today we will be discussing and addressing the most important things regarding learner disciplinary hearings. Again, I'm not going to read the act. I'm not going to read the notices applicable. Rather, I think it's best if we discuss practical things that you can implement in your school that you should know how to do and how to get things right. So first of all, in most schools, discipline is a challenge these days. So don't feel like you're alone. Don't feel like it's only my school where we struggle with learner discipline. It's in most schools a challenge these days. Something that we picked up last year is that for quite some time during the COVID period, learner discipline actually made a turn for the best, where I think whilst this is getting into the new normal, that learner discipline will start becoming a challenge again. Where you guys also know, working with learner disciplines is that it comes and goes in waves. Like we all speak about silly season that comes up in the third quarter, where learners just start acting out because there's not enough sports going on. They're tired, the year has been long. So we always say it comes and goes in waves, with our third term as our silly season. A school can only be functioned if there is proper discipline, and that's why it is so important to never let go of discipline. Sometimes in schools, you will feel like it's just an uphill battle and feel like you would just like to let go. And it's in these schools where the problems and, let's say, gang-related activities and things like that just become so serious that you lose control totally. So a school can only be functional if there is discipline. And I can tell you today, and I can guarantee you that there is still a proper way in which we can maintain discipline in schools. I know most of us come from a time where discipline was dealt with in a whole nother manner, where you would get ses van die bestes if you did something wrong. And that is how we grew up, and we still sometimes feel like a goeie pak slaag or a good hiding can fix all of our disciplinary problems. So I'm here to tell you today that there is still good and proper disciplinary systems that we can put in place to still have functional discipline in our schools. So a good disciplinary system, as well as the correct enforcement of procedures, is a prerequisite for good learner and educator discipline. So let's jump right into it. What governs disciplinary procedures in public schools? Firstly, we will look at the Constitution, and that's where we start, where we look at the Bill of Rights, which establish that you have a right to be heard. If we move down from that, the regulatory document is the South African Schools Act. And here we specifically look at Section 8, which is regarding the Schools Code of Conduct, Section 8 Big A, regarding random search and seizure and drug testing at school, and then Section 9, suspension and expulsion from public schools. Like I said in the beginning, I'm not going to read through the act because each and every one of us can do that. So we're going to focus more on practical implications today rather than just reading through the act. But yeah, these three sections is what's most important from the South African Schools Act. And then when we look at Gauteng, we look at the General Notice 2591 of 2001 and Circular 74 of 2007. This is our core-based documents that will regulate the disciplinary procedure in public schools. Okay, firstly, Code of Conduct. And I don't think people give the Schools Code of Conduct enough credit. The Schools Code of Conduct should be unique to each and every school, and this is a document that should not just be copy and pasted from another school because you like the way that the document is formulated. This is a document that you should really work with to get it applicable to your needs, to your specific school's needs. Every school out there has a code of conduct, must have a code of conduct, and every school's code of conduct can look different. So if we look at Section 8.2, it says the code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. Section 8.4, nothing contained in the Act exempts a learner from the obligation to comply with the code of conduct of the school attended by such learner. So now it's, sorry if you hear something in the background, a bird just flew into my working area. So yes, so this is very important because nothing contained in the Act exempts a learner from the obligation to comply with the Code of Conduct, which means that whatever we put into the Code of Conduct is applicable to each and every learner. Section 8.5 Big A says the Code of Conduct must contain provisions of due process, safeguarding the interest of the learner and any other party involved during the disciplinary proceedings. Okay, so it creates the idea of due process, and we will speak a little bit about due process a little bit later on as well. Then Section 8.5B actually says the Code of Conduct must provide support measures or structures for counseling a learner involved in disciplinary proceedings. So this is in the Schools Act that says that the Code of Conduct must provide support measures or structures for counseling a learner involved in disciplinary proceedings. Yes, so what is misconduct? And this is taken from the General Notice 2591 of 2001. As schools, we sometimes tend to not know when we can act and when we cannot act, or what type of misconduct is within the school's jurisdiction, or what type of misconduct must be dealt with by other institutions. So this general notice defines misconduct as follows. Misconduct means misconduct committed by a learner and includes the following. Misconduct committed on the premises of a school, whether during or outside of school hours. Misconduct committed during any school activity, irrespective of whether it is committed within or outside the school premises and during or outside of school hours. Any conduct committed in or out of school uniform and within or outside the school premises, which tends to bring the school into disrepute, interferes with the governance, authority, and proper administration of the school. Number 3, interferes with the conditions necessary for any school activity. 4, subject to the reasonable exercise of the right to assemble, demonstrate, picket, and petition as provided in the Constitution and the Code is committed with the intention of preventing any person from exercising his or her rights, powers, or duty as a member of the school community, or is committed in retaliation against such exercise, or is prohibited by the code of the school. Okay, so you will see this misconduct definition is really very broad. So it doesn't just indicate that it should be misconduct that happened on the school uniform, in school hours, or in school uniform, in school hours, busy with school activities. So you see, it's far broader than that. Okay, so this is the definition that we'll always go back to if we are uncertain. Sometimes what will happen is we get informed that there was some misconduct that happened at 12 at night between two learners over WhatsApp. And then the school will be, I don't know how this should be dealt with, and whether as school that I can act against this. So once this roll over to the school, once the school is informed, the school has a right to address the misconduct. Okay, suspension. Suspension, firstly we're going to look at who can suspend a learner, and then secondly we will look at the different types of suspension that we can get. So here you will see it's the South African Schools Act indicate what the school governing body may do, and then General Notice 2591 of 2001 shows us what the principal may do. So according to the South African Schools Act, the governing body may, on reasonable grounds and as a precautionary measure, suspend a learner who is suspected of serious misconduct from attending school, but may only enforce such suspension after the learner has been granted a reasonable opportunity to make representations to it in relation to such suspension. Okay, so we sometimes have the idea that only the school governing body may suspend, which is true according to the South African Schools Act. But once we also take General Notice 251 of 2001 into consideration, it indicates when we look at provisional suspension, okay, we see that means, okay, this is the definition, means a learner may be provisionally suspended by the principal from the time charges of serious misconduct. Oh my word. If you just give me a moment, let me just open a window for this bird to exit the room. Sorry, my apologies, the bird is outside. Okay, so you will see when we look at provisional suspension that the principal may also initiate provisional suspension, and that there is space that the principal should discuss this in consultation with the head of department. Okay, so there is a method for the school governing body in terms of the South African Schools Act, and a method for the principal in terms of General Notice 2591 of 2001. Okay, so suspension can take place in two manners. Firstly, before the disciplinary hearing, and this is as a precautionary measure. There is three requirements for this suspension. Is the learner a threat for information, property, or people? Okay, so let's give practical examples of this. Information is there specific information that will that the learner is a threat to? So the learner would, let's say, for example, say that Due to my misconduct, I am privy to certain information which I will destroy. Property, I will burn the school if you continue with a disciplinary hearing, or I will kill someone or slap someone or punch someone if you act as a witness during a disciplinary hearing. Then I have enough means to say that as a proactive and a preventative measure that I can suspend this learner. After the disciplinary hearing, suspension can only be implemented as a sanction, as punitive measure, okay, to a maximum of 7 school days, or when we look at a recommendation for permanent expulsion. So the suspension will then be for 14 days whilst we await HOD feedback, but a little bit more on suspension and expulsion later on. So when we look at a disciplinary hearing, who must attend? Okay, number 1, learner and learner representative. So the general notice defines a representative as follows: to mean a parent of a learner or co-learner or any other person chosen by the learner to represent the learner at a disciplinary hearing. And the big question mark that we always faced with is, can a learner be represented by an attorney? So Circular 74 of 2007 under clause 7.2.3, it clearly indicates the learner has the right to be represented by an attorney. So we have had various correspondences and communications also from the Department of Education, which indicated that an attorney cannot represent a learner in the capacity as a legal representative, but merely as in the capacity of a learner representative. Okay, so that is because a disciplinary hearing is not a court of law, and the same processes will not be followed that will be followed in a court of law. So an attorney sometimes tends to over-formalize the proceedings. Okay, so in this instance, we know that an attorney can be accepted, but the attorney will then be accepted as a learner representative and not as an attorney or a legal practitioner. Secondly, there must be a disciplinary committee, and a disciplinary committee must comprise of the following: 3 SGB members, or this is now according to Circular 74 of 2007, or anyone nominated by the SGB. So who cannot be part of this disciplinary committee? Sometimes we also speak about it as the disciplinary tribunal. So the chairperson of the disciplinary proceeding must be a parent. So the chairperson may not be an educator, a principal, or a learner from school. It must be a parent component from the SGB or someone nominated by the SGB. This is where we look at co-ops, and this is also where Marius Botha Consultants plays a very big role in disciplinary hearings, where you will co-opt one of our team members that will sit as the chairperson of the disciplinary committee and then also as the chairperson of the disciplinary proceedings. Secondly, the principal or learner at the school may not be part of the tribunal. Okay, so we have explained that. The principal, we will get to his role a little bit later on, but a learner at the school, and I think that's for obvious reasons, may not be a part of the disciplinary tribunal because the disciplinary tribunal is the tribunal is the committee that makes the decision with regards to suspension or expulsion or sanction and outcome. Okay, no person with personal knowledge or interest may be appointed to the disciplinary committee, meaning that if I'm the person on the school governing body that investigated certain misconduct, or I know a learner very well, it's maybe my son or daughter's best friend, I may not be appointed because I might then have certain biasness towards the learner when dealing with decision making. And then lastly, the third party that has to attend the disciplinary hearing is the evidence leader. So the evidence leader, I'm not going to address that with you guys today. The evidence leader we will discuss in full during our session on Thursday. The disciplinary procedure. Only a principal may institute disciplinary action. Okay, that's why in very bold there I wrote mandate. Most of our schools these days has someone that is responsible for discipline, a disciplinary head or a person that just has the responsibility to deal with discipline. Therefore, we need a proper mandate in place where the principal mandates and provides an employee or disciplinary head with certain tasks and job requirements. Okay, which will then allow this person to institute disciplinary action. So no less than 5 days notice. So a learner must receive at least 5 days notice before a disciplinary hearing will take place, unless the SGB directs with good cause that a lesser period must take place and then that there is no prejudice to the learners. This meaning if something happened very serious and even the parents indicate that they would like this to be dealt with as soon as possible, that we can move away from the 5 days notice where we can then say by mutual agreement we agree that within 2 days a disciplinary hearing will take place. Okay. The notice in itself as well will be discussed during the next training session, and all the requirements for the notice itself will be discussed with what the role of the evidence leader is and the information that the evidence leader will have to provide the learner with. Okay, lastly, important things with regards to the hearing procedure is if the learner fails to attend without just cause, the hearing can continue in the learner's absence. Here we have taken note that should the misconduct be of such a serious nature that we would like to request recommendation for expulsion, that we would prefer the learner to attend. So if there is no just cause for failure to attend, we will then make, just in this very serious instances, we'll give opportunity for a postponement just once to show from the school side that we have really done everything in our power to get the learner there, to give the learner the opportunity to state his side of the case before we take such a serious decision as to recommend expulsion. Okay, at the end of the day, when recommending expulsion, we make a recommendation to the HOD, which is out of your school's hands. And in all of our preparation and in all of our documentation, it's so important to show that from the school side, we have done everything in our power to assist the learner, to accommodate the learner, but despite that the misconduct is just of such serious nature that it really warrants expulsion. And therefore, if it's not very serious matters, I'd say first-time failure to attend can lead straight to an absentia disciplinary hearing. But if it's very serious matter and we would like to go for an expulsion recommendation, that we give one opportunity for postponement to see if we can get the learner at the disciplinary hearing, because 2 failures to attend, we can just indicate in our recommendation for expulsion that there is no willingness from the learner or his or her parents to work with us, and therefore we had 2 opportunities for postponement and that the hearing had to continue in absentia. Okay, suspension or expulsion is considered unfair even if there is a good and proven reason, but there is flaws in the procedure. Okay, this is what is so very important, is that even if there is really good reason, let's say even if it is that drug dealer that sells dacha on the school ground and it's proven, we have got all the evidence, everything is in order, but the procedure that was followed is flawed, then the suspension or expulsion will be considered unfair. Okay, so a school, the duty is on the school. The school must be able to show that the procedure that was followed is in terms of the South African Schools Act, in terms of the regulations, and in terms of the Schools Code of Conduct. What does this mean? is sometimes in the beginning I spoke about how important a school's code of conduct is. Sometimes a school just adopts a template code of conduct and doesn't follow his or her own code of conduct, which means the code of conduct can also set out certain procedures. If I do not follow my own procedures, then a suspension or expulsion can be considered unfair. Okay, so it's very important. If I adopt a code of conduct, I have to make very sure that this code of conduct has been complied with. And then, number 3, like cases must be treated alike. This means sorry guys for that, this means that if the same, sorry guys, this is now COVID-19 and the technical difficulties that you face when you have to present something at home. So someone literally just pitched up at my house. So I just want to tell them that I'm busy with training and that I can't see them now. So if you just give me a moment. I'm so sorry, everyone. Okay, like cases must be treated alike. So if we deal with one case of dacha or dwellings or anything like that, then we have to deal with these cases all alike. Meaning, if I recommend expulsion for a first-time transgression, then I would most likely have to recommend expulsion in all first-time dacha incidents. Okay. And we will get to mitigating and aggravating circumstances that might change this a little bit later on, but like cases must be treated alike. Now we get to the disciplinary procedure itself. How does it work? Not all of us will sit in a disciplinary hearing, and therefore I'm going to go through the entire procedure and explain it as it will happen. Okay. Firstly, it will be the introduction of our parties, which we now already discussed our parties as number 1 is our learner representative. This is where we will ask in what capacity the learner's representative is there. Because sometimes we don't know who he or she is, and we will then see whether this person can actually attend the disciplinary hearing. We will introduce the disciplinary committee, which comprises of our 3 SGB members, one of which will be the chairperson. This is the person that will take lead during the disciplinary hearing procedure. And this is the person that will work through this procedure as I'm explaining it to you now. And then lastly, we will also introduce our evidence leader. What sometimes is necessary is to also have a scribe. During a disciplinary hearing, so many things can be said, and it can go so quick, and it is the school's responsibility to make sure that there is proper record of the disciplinary hearing procedure. Okay, so that's something that we can also take into consideration, is to maybe appoint a scribe or to then have a formal electronic minutes of the disciplinary hearing. Secondly, we will explain, the chairperson will explain to the learner his or her rights. This rights will also be contained in the learner's notice to attend the disciplinary hearing, and the rights include things such as the following: the right to be represented, okay, the right to a hearing in his or in the language that he or she understands. So when we deal with disciplinary hearings, this is the LOLT of school, the language of learning and teaching. Okay. Further, the learner has a right to call witnesses and to make use of evidence, to cross-examine witnesses and to inspect evidence. This right is also conferred on the evidence leader. But like I said, the evidence leader's duties we will discuss on Thursday. So this is important rights. The learner also has the right to the outcome of the disciplinary hearing, meaning the decision that the disciplinary tribunal will take at the end of the disciplinary hearing. And we'd prefer that to do that in writing. Okay, so this is the rights that we will explain to the learner. After the rights are explained, we will continue with the procedure. The procedure will be explained in full to ensure that all parties understand how the procedure looks. And the procedure looks as follows. The evidence leader will read the charge. The chairperson will make sure that the learner understands the charge and has enough information about the charge, where the chairperson will then give the learner the opportunity to plead to the charge. Pleading, meaning to say, yes, I did it. No, I didn't do it. Guilty or not guilty. And I'm just quickly going to stop there in the procedure to explain to you the following. We work with learners, and this procedure is already very formal. So if we work with primary school learners or learners that is of a much younger age, or we work with LSEN learners with not 100% mental capacity, then we can bring the procedure down to their level. So explain it to them in terms, making use of words that they can understand, meaning that we can indicate that you have to tell me, did you do it or didn't you do it? And we don't just have to stick with the guilty or not guilty or just make use of the big words. It's very important to bring the procedure down to their level to make sure that they understand, to make sure that the disciplinary hearing is also fair and proper towards them. Okay, so just a little insert there. So after the pleading of guilty or not guilty, the yes or the no, this is where the actual procedure will then take place. If the learner pleaded guilty, meaning the learner said, yes, I did it, and confirms whatever the learner is charged with, then the learner will firstly get the opportunity to explain what happened and why did it happen. But because the learner can now basically say anything, it's important that the evidence leader will then also get the opportunity to just set the record straight. This is necessary because sometimes what happens, a learner will be charged with very serious misconduct. For instance, a learner will be charged with selling dagga on the school grounds. When the learner pleads guilty, the learner says, yes, I did it, but then in the explanation would explain something that, well, let's rather use the example where a learner is charged with assault. When the learner pleads guilty and explains what happened, the learner merely explains that it was a little bump, or it was just a tick, I barely touched the person. So that's why it's important that the evidence leader also get the opportunity to confirm the events and to confirm that what happened is actually true. And this is where the evidence leader, it's very, very important that the evidence leader then just give us the correct version of events. And this is where we can then ask the learner a few questions to make sure that this is actually what transpired. Okay, that's if the learner pleads guilty. So if the learner pleads guilty, the learner starts, the evidence leader goes second. If the learner pleads not guilty, then the procedure is as follows. The evidence leader will start by presenting the school's case. This is where the evidence leader can call witnesses and make use of any type of evidence. Okay? During the calling of witnesses and during the presentation of evidence, the learner will get the opportunity to cross-examine the witnesses and to inspect the evidence. The same thing happens to the other side. Once the evidence leader closed his or her case, then the learner gets the opportunity to state his or her side of the case, where the learner has the same rights of calling witnesses, and making use of evidence, and then the evidence leader has the same right of cross-examining witnesses and inspecting evidence. So I'm not going to go into the details of the cross-examination or of the preparation of the case or presenting evidence, because this is specifically what will be discussed during our session on Thursday. Okay, so after the procedure for guilty or not guilty, and we're at number 7 now, guilty or not guilty has been followed. The step from there on is a very, very, very important step, the step of mitigating and aggravating circumstances. Mitigating and aggravating circumstances can only take place in the following 2 instances. If a learner pleaded guilty or if the learner has been found guilty. So if there hasn't been a guilty plea, then that is after point number 7, where the parties will exit the room and only the disciplinary tribunal will stay behind, where the disciplinary tribunal will make a finding on guilty or not guilty. Okay, this is the finding on the balance of probabilities. Balance of probability, if I can explain it to you just very quickly how it differs beyond reasonable doubt, is that if you find someone smoking, and okay, you don't find them smoking, you don't see them smoking, but you can smell smoke. There is cigarettes in their pocket and they have a lighter in their hands. On the balance of probability, this person just smoked. Beyond reasonable doubt, which is actually our criminal measure, is that I actually have to see this person with the cigarette in his or her mouth taking a pull. Okay, so that is not our test when determining a guilty or not guilty finding. The test that we use is the balance of probability. Okay, mitigating and aggravating circumstances will only then follow a guilty plea or a guilty finding. Mitigating and aggravating circumstances is where the learner and the evidence leader both get the opportunity to address the disciplinary committee on reasons why he or she should get the worst possible sanction or reasons why he or she should not get the worst possible sanction. And I always say that this is the part where the whole school comes into play, because this is now the part that is not just dependent on the evidence leader and how well the evidence leader prepared for the disciplinary hearing. This part is on each and every educator at school and each and every person working with the children. We have a code of conduct, like I've spoken about a few times today, and the importance of the code of conduct. So in our code of conduct, it will provide for a specific demerit system. Most schools has a specific demerit system. And that is what can be used as basis for mitigating or aggravating circumstances. Because this will show us in the event where a learner is impossible, it will show us that the learner has been impossible for how many years. Showing us if we just draw the demerit list, it will show us that this is the transgressions that the learner has been doing for the how many years, the talking in class, the not doing homework. And then this can show us how maybe the misconduct has become worse. But also, in another sense, it can show us how a learner is acting out of character. Okay, so sometimes it happens that a learner gets involved in a very big fight in school, but then during a disciplinary hearing, it can be shown that, oh, look at all the learner's credit points. From the school side as well, it can be plead for mitigation to say this learner should not be expelled because the learner has XYZ good points. Look at the credit marks and look at how the learner acted out of his or her character. Okay, remember that the disciplinary committee that sits and makes the decision doesn't have all the information at hand and doesn't know the learner. Okay, so it's important that this is where the background is created of why should the worst possible sanction be presented, or why should the worst possible sanction not be presented to the learner. And then lastly, after mitigating and aggravating circumstances are heard, we would look at an outcome. So this outcome can take place in one or two methods. Some schools prefer it one way, other schools prefer it another way. There's no right and wrong. Some schools would prefer that the disciplinary committee stay behind, make a decision, um, set the outcome, and then call all the parties back in and present it just there and then, same day. Other schools make the decision to say that we would like the outcome to be formal and in writing, and then within 5 school days from the disciplinary hearing. Like I said, there's no right and wrong here. My suggestion would be that if you deal with disciplinary hearings, that is not so serious. Okay? So it's not a case where it would necessarily go for expulsion, but that there is a very big and great lesson that you'd like the learner to learn. Then I'd say, yes, by all means, go for the outcome that is presented immediately. Okay, but when we come to a recommendation for expulsion, very serious matter, it is better to do the outcome within 5 days in writing, because in such an outcome, the learner should be informed of his or her rights in terms of the expulsion and appealing an expulsion. And I kid you not, I have once almost been hit by a mother's handbag when I in person explained that we will now be making a recommendation for expulsion. So sometimes, especially when it's a bit more serious outcomes, we would say do it in writing, do it at a later stage to just avoid that immediate in the heat conflict. Okay, so outcome, this is just quick. This is most probably not going to be on any of you, but this is the outcome style that the disciplinary committee will have to follow. So the outcome in short is that the charges must be listed, grounds for the findings, list the findings, refer to the evidence, give reasons for the outcome, and then give the sanction. Okay, so if there is a guilty plea, we will have to say that we accept or reject the guilty plea. Okay, and then if there is a not guilty plea, we would have to indicate that there is then a guilty or a not guilty finding on the balance of probability, and then provide the reasons therefore. Possible sanctions, and this also is something that is very school to school. Okay, your school will most probably decide how we would like to deal with different types of misconduct in different types of manners. And this is also something that we can include into our code of conduct to say that we would like to deal with this set of misconduct in this manner. That something would lead to maybe a verbal warning, some things will lead to parent interviews, some schools still make use of detention, other schools make use of, let's say, academic detention. Some schools do detention during lunch breaks. Some schools do detention once a month, others once a quarter. So it really depends on what your school likes. Some schools also like to make use of community service. So community service is 100% fine. You can still do that, but make sure that there is good and proper monitoring. So there must be enough personnel looking at the learners, especially let's say if we say that the learners would have to go gardening, make sure that the learners cannot, for instance, put a garden fork through their feet, because things like that happen. We know we're working with schools. Then it's very important that whatever type of sanction needs to be followed with a formal type of warning. A written warning, we have to indicate for how long, for what period. So written warning, a final written warning, and then we'll get to suspension, like I've indicated previously in our session. If we suspend as a punitive measure, we then can suspend up to 7 school days. Suspended expulsion is not necessarily something that existed before the Department of Education came into play. And the reason we also put that there is, you guys will know when we recommend expulsion to the Department of Education that they will come back and say, the expulsion is granted, but it's suspended for a period of 12 months. It's as if they decided to give another step of warning before we get to the expulsion. So if the learner already had a final written warning, they will suspend the expulsion for another 12 months before, if the learner then in that 12 months does something, they will provide us with the expulsion. So sometimes what we have started doing at school level is to say that if there was already a final written warning, we will continue the next disciplinary hearing, will have an outcome with a lot of things that the learner have to comply with, but the type of warning that we will then provide the learner with is a suspended expulsion. Then we already do that at school level, that once the learner continues to transgress and we remove the recommendation for expulsion, that we can already indicate to the Department of Education, listen, the learner has already been on a suspended expulsion, and that the natural next step should be permanent expulsion. Okay, once we look at expulsion, and this is where I'm quickly going to discuss expulsion with you. The learner has to be suspended for a period of 14 school days. So what this means, actually, according to the South African Schools Act, is that the head of department at the Department of Education has 14 school days basically to come back to indicate whether the expulsion can take place or whether it can't take place. But we all know that this 14-day period is non-existent dealing with the Department of Education, and then that they take more like 2 to 3 months to come back or to get back to us on a recommendation for expulsion. So what you can do here is either, number one, the learner can come back to the school after 14 days, provisionally pending the outcome of the HOD, where if the learner then transgresses, just a follow-up recommendation for expulsion will be made to the Department of Education. So that's option number one, the learner comes back to the school provisionally. Option number two is where we can apply to the HOD just to extend the 14-day expulsion until they come back with a recommendation for expulsion or not. So also what happens here is when we look at suspension that is longer than the 7 or the 14-day period, is where we will look at suspension based on the safety regulations. So in our South African Schools Act booklet, you will see at the back there is safety regulations, which indicate that no person is allowed to enter the school grounds under the influence of any illegal substance. So in that manner, we can suspend a learner pending a negative drug test. So there's other different, more creative ways that we can also suspend learners for a longer period than just the 7 or the 14 days. When we get to expulsion, and that will also be discussed a little bit more on Thursday, it is the school's responsibility to create this expulsion pack with all the information regarding this learner. And the Department of Education has become more creative, let's say creative, in the things that they request from the schools. So the school must make sure that when we deal with learners and when we deal with very difficult let's say difficult learners, and we deal with difficult parents, that we have proper record of what is going on, proper record of each and every verbal warning, of each and every parent interview, of each and every counseling session that we provided the learner with, to make sure that we can really have a proper pack of information that we can provide the Department of Education with, and to make sure that we can get that recommendation for expulsion. Okay, a few things that we have to take into consideration is Section 33 of the Bill of Rights as contained in the Constitution. So the disciplinary hearing takes place according to the prescribed procedure based on the basic principles of fair administrative law. Okay, so that's why sometimes we will speak about a disciplinary hearing as an administrative tribunal and not a court of law, because admin law is applicable to disciplinary hearings and not civil or criminal litigation rules and laws. The accused learner's right to a fair hearing is further endorsed in Section 33 of the Bill of Rights, as contained in the Constitution. These principles are not only related to the procedure that is followed, but also to the way in which it is done. So here we have to address double jeopardy. When a learner commits misconduct on the school grounds, we want to be proactive and quickly get everything done. And sometimes what happens is that I will already furnish the learner with debit marks. So let's say assault will be 250 debit marks for a certain school. Then after I've furnished the learner with the debit marks, I will then continue to schedule a disciplinary hearing. And when we get to a disciplinary hearing, the learner representative or the attorney now representing the learner will ask, but have you already furnished the learner or supplied the learner with debit marks? And you will say yes, because you have got everything in order and you have done everything according to the book. But what that means is if you provide a learner with debit marks, you already punish the learner, meaning that the learner already received a sanction and that a learner cannot be punished for the same transgression twice. So how do we deal with this, or how do we get around this? If a learner misconducts on the school ground and we would like to furnish the learner with debit marks, the debit marks will come as a result of the outcome of the disciplinary hearing, or we can indicate it on the debit mark sheet, but we will leave out the amount component. Okay. Another example of this is if a learner did something, let's say in the beginning of the year, was involved in an assault, and you provided the learner just with a verbal warning. Later the year, the learner has now again gotten involved in a huge school fight, and then the learner now has to be charged with a disciplinary hearing. And now you say, but previously the year, the same thing happened, but the learner never had a disciplinary hearing for that. So why don't we just charge the learner with 2 counts of assault? And you charge the learner with the assault from the beginning of the year and now with this assault again. But if you already gave the learner any type of warning in the beginning of the year, you cannot charge the learner with that again. Okay, so sometimes it's necessary to just think about the misconduct and the type of outcome that you would like to achieve before just acting. If something is very serious, don't just provide debit marks or don't just give a warning. If something is very serious and you would like to take it to a disciplinary hearing level, then make sure that there hasn't been any forms of punishment beforehand. That now doesn't include a conversation or investigation and things like that. I'm talking about methods of punishment and sanctions. Okay, so we've come to the end of the session and I see that we have one question here. Should the scribe be a member of the SGB or could it be a staff member of the school? Okay, so the scribe can be a member of the SGB or a staff member of the school. There is no requirements for a scribe other than it would be a person that takes proper record of the disciplinary proceedings. The scribe will also not partake in the disciplinary hearing in any manner other than taking notes. Okay, so that's why there is no formal requirement for who a scribe should be or shouldn't be. It can be absolutely anyone. I just say refrain from it being a learner from school and rather make sure that it is a staff member, maybe even the grade head or something like that, or an admin lady at school, or if there is an extra SGB member that would like to sit in the disciplinary hearings, that it can be a SGB member. Listen, disciplinary hearings is complex but it should not be something that you're scared of. It should not be something that is considered very difficult. If you have a proper procedure that works for you and for your school, that is something that is super convenient and that you can then just use going forward. I know it's maybe difficult to get that first hearing. Maybe you are a newly appointed disciplinary head or you are now a grade head and you do not know how this works. This session of today combined with the session that we're doing on Thursday would be something that would really equip you to know how this works and to know what documentation needs to be in place. And therefore, we are also there working with our member schools. You can always check charges with us, check misconduct types with us. You can always request us to be the chairperson of the disciplinary hearing. Quickly ask us a question if you are not sure with who is supposed to attend. You're now dealing with a difficult parent, how to deal with the parent. Should you provide information beforehand? Shouldn't you provide information beforehand? These are the type of questions that you can just quickly discuss with us, a quick telephone call. That's why we're also here, and that is also our role to assist in learner disciplinary hearings. And then I hope from today that you take it that the most important document that you actually have to go and read is your code of conduct, to make sure that the code of conduct is applicable to your school and is that you are satisfied with it according to your school's needs. Like I said, each and every person out there, each and every person, each and every school out there has a code of conduct, and that code of conduct is unique to your school. Okay, and that is what makes your school different than any other school. And once a learner or once the parents of a learner enters a learner into your school or into that school, that parent and learner says, yes, I accept this school's code of conduct. And then lastly, I'd just like to read this for you guys. And it is from Guidelines for Code of Conduct for Learners, Clause 6, Responsibilities of Parents with respect to the Code of Conduct. And this is something that should make your hands as educators strong, is to say the ultimate responsibility for learners' behavior rests with their parents or guardians. It is expected that parents will support the school and require learners to observe all school rules and regulations and accept responsibility for any misbehavior on their part, and take an active interest in their children's schoolwork, and make it possible for the children to complete assigned homework. Okay, so the ultimate responsibility for learners' behavior still rests with the parents or guardians, and that we as schools can act against misconduct. At the end of the session, I'll send you the PowerPoint in Afrikaans and English, but I'm also going to send you the General Notice 2591 of 2001 and Circular 74 of 2007, so that you can have all of these documentation close by to always make sure that you can follow the correct procedures. It's always a place where you can quickly go to just to check something. And then also at the end of General Notice 2591 of 2001, you will see there is Schedule 1 and Schedule 2 misconduct. It's misconduct set out by the Department of Education as misconduct that may lead to suspension and misconduct that may lead to expulsion. And this will also be discussed a little bit more in detail with regards to charging learners with misconduct in our session on Thursday. So I hope if you have attended today and you're a disciplinary head that you will also attend the evidence leader session on Thursday. If you can't make it, remember at the end of the whole series, then we will upload all of our sessions on YouTube. Thank you very much, and I hope you had a very good day. If there's any other questions, we'll stay on for a while and you can then just put it in the chat box. Thank you. I see there's one more question that came in. So let's quickly address that one. When recommending expulsion, it takes time to compile the report to the HOD. Does this fall within the 14 days of provisional expulsion? So I understand that it takes some time. My suggestion would be that it be sent within 14 days for the provisional expulsion. These 14 days start walking, if I can call it that. It starts walking from the time that the learner receives the outcome. So that's why I'm saying when we deal with recommendation for expulsion, let's rather do an outcome within 5 days from the disciplinary hearing. So that gives us our first initial 5 days. And then from there on, once the learner has received the outcome, it would be 14 days provisional suspension. So it gives us more than enough time to prepare the expulsion report. I think what is important is that once we charge a learner and we know that the misconduct is of such serious nature that it warrants permanent expulsion, that we already start getting the file ready, because that is the information actually that will be necessary for the disciplinary hearing, for the aggravating circumstances, and then we already have that in order when we have to recommend the expulsion, so that we can do that as quick as possible, because like I'm explaining, we are waiting 4 months on end on the Department of Education, so we would like to get that documents out as soon as possible. So yes, we would have to do that within that 14 days, because we would not want to inform the parents of the appeal procedure and they appeal a recommendation that we have not already sent. So remember, once we send the outcome, in the outcome we inform them of the appeal procedure. So more or less, if we can say that within the first 5 days, let's say within the first week of the first 14 school days that we send the recommendation for expulsion, then sometimes it takes a little bit longer. There's no formal requirement as to when it should be handed in, but I'd say the sooner the better. Thank you very much, guys.